Lesson 38, Landmark Supreme Court Cases, the 4th, 5th, and 6th Amendments. Lesson 39 will be on the 14th Amendment. Okay, let's start with the 4th Amendment here. Landmark case, 1961, Mapp versus Ohio. This is one of the most important cases with regards to the 4th Amendment. Mapp versus Ohio. A little background of the case. Prior to the Mapp case, about half of the states in the U.S. were allowing illegally seized evidence to be admitted into the case against the accused. This is illegally seized evidence. You may wonder, well, is that not a violation of the 4th Amendment? How can that be? Do not police officers need a search warrant? Okay, what does the 4th Amendment say? Again, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The 4th Amendment. Okay, this is our amendment against, our protection against unreasonable searches and seizures. Notice that you have to have a search warrant, and it's issued upon oath or affirmation. That is a judge, usually a magistrate judge, will issue a search warrant, and it's really specific about what has to be searched and seized. Okay, so what's the problem here? Remember, the Bill of Rights was originally written to prevent the federal government from infringing upon the rights of citizens. States had their own bills of rights. Therefore, the Bill of Rights only protected citizens from the federal government and applied only to the federal government and not to the states. That's originally. So, the 4th Amendment applied only to federal criminal cases. Therefore, illegally seized evidence was not admissible against an accused in a federal trial, but since the 4th Amendment did not apply to states, states could admit illegally seized evidence in court against an accused. And so prior to 1961, about half of our states were allowing illegally seized evidence by the police to be admitted as evidence into the case against an accused. Is that the case today? Can states ignore and violate the Bill of Rights because it was written originally to apply only to the federal government? No, of course not. States today cannot violate the Bill of Rights. What happened? What changed? First of all, the 14th Amendment was passed in 1868. The 14th Amendment is one of the most important amendments to our Constitution. Section 1 of the 14th Amendment has 4 significant parts. It defines a citizen. It also says that states cannot deny the privileges and immunities of citizens, cannot deny due process for any person, nor deny equal protection for any person. This is all in Section 1 of the 14th Amendment. Here is the phrase with respect to citizenship. All persons born or naturalized in the U.S. are citizens of the U.S. and of the state wherein they reside. Here's the privileges and immunities clause. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. The due process part, nor shall any state deprive any person of life, liberty, or property without due process of law. And then the equal protection clause, nor deny to any person within its jurisdiction the equal protection of the laws. So with the passage of the 14th Amendment, it does sound like states cannot violate any part of the Bill of Rights. I think the 14th Amendment was passed in 1868. Remember how the appellate process works, though. The Supreme Court cannot just declare laws or government actions unconstitutional. Plaintiffs have to challenge or appeal those laws and government actions in court, and then the Supreme Court has to agree to hear those challenges or appeals. So this is exactly what happened in the Mapp case. In fact, the Mapp case was a significant step in what we call the nationalization of the Bill of Rights, meaning that the Bill of Rights was also to apply to state and local governments as well as to the federal government. The Supreme Court used those very important clauses, privileges, immunities, due process, equal protection, to incorporate the Bill of Rights into the 14th Amendment. That's another important way of saying that the Bill of Rights applies to state and local governments as well as to the federal government. The Bill of Rights has been incorporated through the 14th Amendment to apply to the states. From 1961 to 1969, Chief Justice Earl Warren was the Supreme Court Chief Justice, and the Warren Court examined almost every aspect of the criminal justice system in the United States, using the 14th Amendment to extend constitutional protections to all courts in every state. The Warren Court was a very important Supreme Court. This was a very important period, 1961 to 1969. During those years, cases concerning the right to legal counsel, confessions, searches, and treatment of juvenile criminals all appeared on the court's docket. Now, we're going to be taking a look at several of these cases. The Warren Court's revolution in the criminal justice system began with this Mapp case, the first of several significant cases in which it reevaluated the role of the 14th Amendment as it applied to state judicial review. Okay, Mapp, again, let's go back specifically on this Mapp case. It was the beginning of a series of landmark cases in the 1960s that extended the rights of the accused in our criminal justice system. It protected the rights, extended the rights of the accused in our criminal justice system. Okay, the case came before the court in 1961, but the background of the case occurred in 1957 in May, where police officers in a Cleveland, Ohio suburb received information that a suspect in a bombing case, as well as some illegal betting equipment, might be found in the home of Dalree Mapp. 3 officers went to her home and asked for permission to enter, but Mapp refused to admit them without a search warrant. 2 officers left, 1 remained. 3 hours later, the 2 returned with several other officers, brandishing a piece of paper, waving it in the air. They broke through the door. Mapp asked to see the warrant and took it from the officer, putting it in her dress. The officer struggled with Mapp, took the piece of paper away from her. They handcuffed her for being belligerent. They did not find the bombing suspect or the gambling equipment thought to be in her home, but they did find child pornographic material in a suitcase next to her bed. So on that evidence, she was arrested, prosecuted, and convicted for possession of child pornographic material. Dalree Mapp. So basically, Mapp was convicted on the basis of illegally obtained evidence. Her lawyers appealed the conviction, and the case went all the way to the Warren Court in 1961. The court ruled, quote, from the majority opinion, all evidence obtained by searches and seizures in violation of the Constitution is, by the Fourth Amendment, inadmissible in a state court. Which clause in the 14th Amendment do you think Ohio violated when the police arrested Dalree Mapp and when the state court convicted her? Yes, the due process clause. In a later lesson, I will be taking you through that the due process rights of the accused from the moment of arrest all the way down through the trial. The ruling in this case established what we now call the exclusionary rule, meaning that any evidence that has been illegally searched and seized is excluded from the trial. It cannot be admitted into evidence against the accused. That evidence is therefore suppressed. Prior to the start of a trial, defense lawyers who think the police has illegally searched and seized evidence against the accused will request what's called a suppression hearing to get that evidence thrown out before the trial even begins. The judge will have to rule on the admissibility of the evidence. Huh? How's the police trampling my rights a good thing? Exclusionary rule, meaning that evidence cannot be used against the accused if it is not legally searched and seized. The Mapp decision was historic and controversial. It placed the requirement of excluding illegally obtained evidence from court at all levels of government, not now just on the federal government, but all levels of government. State and local governments cannot illegally seize evidence and then have it introduced into a trial against the accused. So what happened to Dollree Mapp? Her conviction was thrown out and she was set free. Critics would complain that criminals get more rights than do the victims. Of course, I would say requiring law enforcement to take care and due diligence in the collection of evidence, the rights and protections of all of us, including the wrongly accused, are guaranteed. In other words, law enforcement, do your job carefully, do your job well, follow the Constitution, and we won't have a problem. What about students' Fourth Amendment rights? Do you, as students, have any? That will be the subject of Lesson 39.